Your Honor, he enters a plea of not guilty.
Okay.
Plea of not guilty is noted. Once again, this case is assigned to the Division III docket of Judge Putman. Court would put it down for reappearance in front of Judge Putman on September 8th.
Your Honor, I would ask that the case be transferred to this division.
This individual has other cases on this division's docket?
I believe it is.
All right. I will then, I'm going to transfer the case to Division 4. Set it for, I'm going to set it by scheduling, transfer it to Division 4, set it by scheduling order. In accordance with the scheduling order, it'll be set for trial the week of April 24th, 2017. Pre-trial will be March 23rd of 2017, and a status reappearance will be set for February 23rd of 2017. I'm also going to put it down for, does anyone recall what other dates we have this defendant coming back to court in the fall?
His other cases that cite pending in that case. They're waiting the results to be taken care of, and so that will have an impact on where we go, Your Honor.
Okay. I was going to say we need to we have psychological evaluation pending. That's right. I'd forgotten that. All right. We'll so really the speedy trial is that going to be filed in this case?
Your Honor, I have not made that decision yet.
Okay. Well, as soon as you do, please let us know.
Your Honor, I would anticipate making that decision
16-238, that's his other case.
before the day is out, Judge.
Pardon?
I think I'll make that decision before the day is out.
Okay. Do we have the other case here?
No. We have our file, and we're not having the court file.
When was that psychological evaluation filed? In 16-238. August 12th is the date that case went into suspension in terms of running of speedy trial while that's pending. Court's going to direct that an evaluation be made in this case as well.
Thank you.
That this case be included in the evaluation that's already been ordered. I don't see any point in not doing it in both of them. That will be, the court's going to leave the order in place covering both cases for that evaluation, and that'll be the order of the court. The scheduling order, as I've already said it, will remain in effect and be the scheduling order for the case in the future. But at this point, that's where we are. Any other matters to come before the court?
Yes, Your Honor. Your Honor, his bond, I believe, is set at $50,000. Your Honor, we would request a bond, not only in this case, a reasonable bond, but in this case and in the previous case. I understand the state's going to argue that the allegations occurred while he was out on bond. Your Honor, he was under the care of a caregiver. The primary caregiver, Ms. Sharon Davis, will be in the courtroom today. In fact, she may be here now. She is in essence his guardian, may even be his legal guardian. We've been asked that his bond be reduced. We've been asked that he be allowed to return to the care and custody of his guardian or his pseudo-guardian, Ms. Sharon Davis.
Your Honor, the position of the state in this matter is that is not appropriate. We tried that the first time and did some things, including an ankle monitor, to allow this to happen because of concerns about this individual's mental health. Those assurances were made to us by the caregiver and those individuals, and that was not successful. That's why there's new charges. That means that the exact same thing happened again. And so to protect the people of the state of Arkansas, Your Honor, we think it's appropriate, pending this psychological evaluation, to remain in custody with those back to the county sheriff's office.
I don't think sorry to interrupt.
Go ahead.
I don't think the allegations in the second charge are exactly the same. I think the allegations here are exposure to a minor. You know, this may or may not be a criteria for the court to consider, but this young man is not a good candidate to be housed in the Baxter County Jail. And maybe we don't have a good alternative for that. But because of the admitted mental handicaps that he has, he does not function well in a jail type environment. He functions well in a caregiver type environment. I understand Mr. Etheridge's concern. I think that Ms. Davis can address those.
Well, at this point, the court is going to. The court feels that the public has a right to be protected from this, and I will consider as we go along in this process. I wish we could accomplish a prompt evaluation that would give us some guidelines or give us some idea of what it's going to take to bring this individual's behavior under control, or at least what's required. And with that in mind, at this point, the court is going to provide leave the bond set at, I've set it at $50,000. Well, actually, I don't think there should be any bond at this point until we get an evaluation and determine what the risks are, get some idea of what the risks are. At this point, the risks seem unacceptable to me. We're talking about events that have the potential to be extremely traumatic to children. And it's my understanding of the facts of this case and the previous case that you know there's a sequence going on here and while I'm sympathetic to Mr. Cooper's argument with respect to that he's not a good candidate to be in jail, I think the risk to young people overrides that, and I will direct that the jail I'm going to direct that the Baxter County Jail make special arrangements to place him in as best as their facilities allow in some kind of situation where he's not exposed to any abuse as a prisoner in the jail, and house him in the jail. And I'll be glad to consult with counsel, the state, and the sheriff about this direction, and then any other suggestions that anybody has for how we accommodate this situation. But right now I recognize that it's a problem for him to be in the jail, but I think that problem is overridden by the risk to young girls in particular in the community, which I think takes priority.
No. Your Honor, this does not relate to the bond argument. Since I stopped speaking, Ms. Davis has arrived. In addition, since he's going to be continuing incarceration, I would ask that she give us a list, which I can provide to the jail, of his medications, or possibly even bring those medications. It's very important, Mr. Eaton, stay on those medications.
Yes, I agree. And so, and that may pose a problem for the jail, that we need to modify what I'm ordering after the jail finds out what's necessary. But that's fine. I want him to be while in jail. I want him to be protected from any form of abuse he might be subjected to, and I also want him to get his medications and other necessary things to accommodate that. I'd also like to expedite the evaluation in any way possible.
Thank you, Your Honor.